Good day. My name is Kyle Yoder, and I'm here today to talk to you about the Judiciary's COVID-19 response and recovery process. In doing so, I want to talk to you about some of our structure in the judicial branch, how our processes are governed, some of the challenges we faced with COVID-19, and some of our success stories. I currently work in the Administrative Office of the U.S. Court's Emergency Management Preparedness Branch. In the role of an emergency manager, I provide the courts and the administrative office advice and guidance about COVID-19's impacts on our potential operational impacts and some of the things we can do to mitigate those impacts, as well as facilitating conversations with our external partners in the U.S. Marshals, Federal Protective Service, General Service Administration, and public health agencies. To begin with, I want to talk to you a little bit about the judicial branch structure. In terms of structure, the judicial branch is led by the Supreme Court and the Chief Justice of the Supreme Court. The Administrative Office Director, the AO Director, reports to the Chief Justice of the Supreme Court, and underneath the Administrative Office, not in terms of leadership but just structure, are the 94 districts and 12 circuits that comprise the judicial branch across the nation and islands such as Puerto Rico, Guam, Northern Marianas. The Administrative Office oversees the funding and guidance put forth to the district courts in terms of operating human resources, budgeting, procurement. However, the district courts are autonomous in terms of process and procedure within their districts. The districts being directed by the chief judge of the district court within the district or the chief judge of the bankruptcy court within a district. Within a district, you have 4 to 5 primary offices, those being the district court, which handles criminal litigation and non-criminal trials, bankruptcy court, which handles bankruptcy proceedings, federal bankruptcy proceedings, probation and pretrial offices, which oversee pretrial confinees or pretrial home confinees, and post-trial, post-conviction parolees and those programs. And you also have the federal defender offices, which provide defense to federal litigants during trial. In terms of processes, these are governed primarily by 28 U.S. Code 452, which states the courts shall always remain open, meaning from a continuity perspective, the court process shall never be disrupted or not available to a person, a United States citizen, at any time, regardless of size, scale, and scope of incident. From an emergency management perspective then, especially from a COVID perspective, you can see where that immediately presents some challenges, especially when you factor in social distancing and lockdown measures that have been imposed or by governors of different states across the nation. Some of those challenges included a litigant's right to speedy trial and how to address that when we could not sit in-person proceedings, especially since a litigant underneath the Sixth Amendment can choose to have an in-person proceeding versus a video proceeding or a delay in their trial. Other challenges faced were things such as the HEROES Act, which, because of COVID-19 in prisons, included provisions for early release of pre- and post-trial confinees. This burden that was placed on the probation and pretrial offices was unanticipated and, of course, was not built into the funded annual structure. The CARES Act, which included authorizations for use of video and teleconference line to hear trials, included provisions for re-examining those actions within a district and recertifying those actions within a district, and also how they should be used primarily for felony pleas and sentencing or relaxed in-person standards in current federal courts to support those. Those things drove institutional challenges. Some of those challenges were audiovisual infrastructure or lack thereof. We are heavily reliant upon our federal partners as we don't have, except for our staff, any tangible resources. Our security is provided by the Marshals and FPS. Our confinees are housed by the Bureau of Prisons and transported by the U.S. Marshals. our buildings are leased from GSA. So in terms of infrastructure, we have had to facilitate conversations and meetings with the marshals and the Bureau of Prisons to try and stand up a robust infrastructure across the nation where we could support video conferencing and telephonic conferencing of litigants. Telework was also a challenge. Primarily, the courts operate on an in-person basis. Wide-scale and robust telework was a foreign concept at the onset of COVID-19 to most courts and districts. That meant that the infrastructure to support the widespread telework, i.e., transportable laptops for everyone to take home, printers, VTC lines, robust backbone infrastructure on an IT side to support the increased video conferencing load and the bandwidth to do that were all things that had to be addressed as we progressed through the COVID-19 pandemic. As it looked like we were having a downturn of cases, we addressed another challenge, which was how to effectively and safely return to our facilities that we had closed to the public, and how to begin rehearing in-person hearings and transitioning back from a video teleconference or telephonic conference model. This involved enlisting the aid of state and local public health agencies who we traditionally did not have robust contact or connections with, as well as using private practice epidemiologists across the country. Some of the challenges associated with that were that epidemiologists still are figuring out COVID-19 and some of the science behind COVID-19. So an epidemiologist procured and enlisted by the District of New York, for example, had a completely different perspective on airflow within a courtroom, the use of plexiglass, plastic face shields, and their effectiveness versus an epidemiologist, say, in California, and trying to develop a national consensus on the differing perspectives on these things is an ongoing challenge. Also, we face the reactions driven by news reporting with our judges. Obviously, when a judge in a district hears on the news that there is an outbreak of epidemic proportions within their area again, they want to know what the administrative office is doing to help them address it. So we are constantly taking news and vetting it against data-driven analytics from HHS, CDC, World Health Organization, and state and local public health offices to help inform the decision-making of the judges at the district level. One of our greatest challenges was reporting and situational awareness on a national level. We did not, at the onset of COVID-19, have a common situational awareness portal, and we relied heavily on email to individuals and individual phone calls and the traditional phone game of passing along messages from one person to the next. So that was also one of our greatest successes. We leveraged data-driven analytics and tools such as ArcGIS and Geospatial Enterprises and Tableau to create a portal of common situational awareness amongst the courts, to provide 14-day trend analysis for their district or divisional office based off data coming out of their specific counties, to look at the availability of hospital bed space in their area, the availability of testing, the positivity rates of testing, and bring that together in a model that a judge could understand easily and base an operational decision off of. We also leveraged our internal and external web pages and hosting sites for information sharing with not only our district partners, but also within our district employees and our public constituents. Between the pages, we established a COVID-19 internal web page that posted all the orders that judges were issuing so that other judges could see what was being done and perhaps emulate it if need be as a best practice. Posted policy and guidance coming out of the AO in a quick reference format and organized it into categories. So if somebody had an issue or a question, for instance, about smoke testing within a facility and the efficacy of that and what to do with that in terms of decision making, there was a section they could readily and quickly go to or be directed to pull up information of what had been done in the past and checklist and materials on how to apply it to their current situation. For our constituents on our public-facing web pages, we quickly leverage those to post closing hours or modified operational hours of facilities, modified processes within the facilities for them to use, and point of contact phone numbers in case something arose and they needed to ask for a continuance or delay or reschedule an appointment. In addition, we changed some of our underlying policy and guidance to allow more flexibility within the court and the district offices to support the last-minute changes that arose due to COVID-19 positive test of our constituents and our clients. We also were able to effectively implement a standardized phasing model based off the nation's three-phase model that came for reopening the nation. Ours was actually 4 phases and is still currently in use, and includes checklist and guidance for contact tracing, as well as health screening at entrances of courthouses and other tools and templates to help district courts and judges through the decision-making process of whether to reopen, close, retighten specific measures, loosen measures based on what they're seeing with COVID case counts and trends in their area. And then we were able to leverage and use associated events as COVID unrolled to capture lessons learned and identify and correct institutional capability gaps. I mentioned on the onset of this our lack of robust video and telephonic conferencing capability. We've leveraged COVID-19 and adopted a lesson learned to create a working group to address creating a national standard of equipment and funding and processes for utilizing telephonic and video conferencing as a tool within the courts to support operations as we're in COVID and then moving past COVID, incorporating it into our long-term guidance. So I know this was a very brief spiel. If you have any questions, please feel free to reach out to me with the contact information that's been provided to you, and I thank you for your time.